Good afternoon and welcome to the New Civil Liberties Alliance. Today's Lunch and Law program is entitled, Will SCOTUS Topple the Government's Censorship Industrial Complex? And we have three guests, exciting guests, to talk about that today, all of whom were in the Supreme Court yesterday to listen to the oral arguments in the Murphy v. Missouri case at the Supreme Court. And of course, two of them are clients of NCLA and plaintiffs in the Murphy v. Missouri case. To my immediate left is Jayanta Bhattacharya, professor of health policy at Stanford University Medical School and the director of Stanford's Center for Demography and Economics of Health and Aging. To his left is Dr. Kheriaty, MD, and a physician specializing in psychiatry and author of 3 books, including most recently, The New Abnormal, The Rise of the Biomedical Security State. Aaron is a fellow and director of the program in Bioethics and American Democracy at the Ethics and Public Policy Center. And to my far left, really only geographically, is Jenin Younes, litigation counsel here at the New Civil Liberties Alliance, and the person who has been spearheading our efforts, not just in the Murphy v. Missouri case, but really on all of our COVID cases from the very beginning of the pandemic. And I think it's fair to say if there had not been a pandemic, Jenin might not be at the New Civil Liberties Alliance. But we are. So if you're looking for a silver lining, there it is. We're delighted to have her. So as I mentioned, all of us were at the Supreme Court yesterday for the oral argument. And there's already been just a slew of commentary on Twitter and elsewhere. I don't know if any of it's been censored or not. I haven't heard about that yet. But maybe I'll start. The first question, maybe Jenin, I'll start with you. Was there anything that didn't come up at oral argument that you thought could have come up or maybe should have come up in front of the justices?
Well, there were a lot of things, but I'll mention the top few. First of all, the principles underlying the First Amendment I don't think were adequately discussed. The reason we have a First Amendment is because nobody has a monopoly on the truth, and we understand that the way to deal with bad ideas is to counter them through more speech, not through censorship. And that really wasn't discussed, and many of the justices appeared to presume that the way, that it's a problem if there's bad speech out there, and the solution to that is to take it down. And I really wish it had come out that that's why we have a First Amendment, because the framers understood that wasn't the way to deal with problematic speech. Also, what didn't really come out was that the things that our clients were saying were true. I mean, to the extent you can know anything to be true, they've turned out to be correct. And it was the government that was saying a lot of untrue things with respect to natural immunity, vaccine stopping transmission. The
source of the Wuhan virus.
Yeah, exactly. Which again illustrates why we have a First Amendment, because the government doesn't have a monopoly on the truth. And we reach the truth through discourse and dialogue, not through censorship.
And sometimes the government might know the truth and they're not willing to say it for political or other reasons. And
right.
So other people need to be able to say the truth too.
Right. And several of the justices got hung up on sort of these national security. Well, what if somebody posts classified information? Are you really saying the FBI or the CIA can't contact the companies and ask them to take it down? That's not our case. You don't have to answer that question. And it's a different issue.
One of the things that I think has gotten a lot of attention online and elsewhere was Justice Jackson's comment. I'm going to quote her directly. She said, "So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways." Yes, that is correct. That would be the role of the Constitution, is to hamstring the government. So now I cut off the quote a little bit. She did say in the most important time periods, but in the most important time periods, I think is when constitutional rights matter the most, not when they get suppressed. Dr. Bhattacharya, how about you? Was there anything that you thought maybe could have come up either on the truth point that Jenin was making or something else that you thought maybe you would like to have heard?
Let me just quote Justice Jackson for another thing she said. She made this analogy or this hypothetical situation of kids jumping out windows.
On a TikTok challenge.
Yeah.
On a TikTok challenge, right? So you jump out a 1-story window, and then I jump out a 2-story window, and then the kids just challenge each other to jump out higher and higher windows. The irony is that it was the government that closed the schools. It was the government that harmed the kids. It's the government that jumped out the windows, told the kids to jump out the windows, and then censored the people who are telling the kids not to jump out the windows. if I'm going to carry this all the way through. I mean, I think what Jenin said is to me was the biggest takeaway. It was. I mean, actually, during the argument, I wanted to jump out a window. It was,
it's very hard when you're in the room not to stand bolt upright and shout something out sometimes. You're missing the point.
They really were. I mean, I think and there was another analogy they made. Someone made that we can call the Washington Post and tell them this story is wrong, and how come the government can't just call Twitter and say, you've allowed Jay Bhattacharya to be on there, the fringe epidemiologist? That's bad. And the problem with that reasoning is that there's all kinds of First Amendment cases that protect the press. They have no worry about their business being destroyed if they tell the government to go take a flying leap. That's not true for the social media companies. Like you read the evidentiary record of the Missouri versus Biden case is absolutely shocking. Essentially, the government threatened in effect. I mean, with the social media, you have the FBI calling Twitter and saying, you better take this down or else. I mean, what's going to happen? I mean, you're gonna worry about things. At least I would. I mean, so I think some of that did come out, but not quite as forcefully as I'd liked.
I thought Justice Alito did a nice job of comparing and contrasting all the things that happened to the social media companies. And he said, you don't see this happening to print media. And he posited, and I think he's right, that Section 230 may be one of the reasons for that. For those who don't know, the social media companies have something called Section 230 immunity. And what that means is if they choose to censor you, you can't sue them for that, the way that you could sue the newspaper under certain circumstances if it libeled you or something like that. The social media platforms have immunity from that. Well, the government's basically piggybacked on the immunity of the social media companies to exert pressure on them in ways that they don't exert pressure on print media. And I was glad to see Justice Alito seem to get that point, and maybe he'll be able to convey that to the other justices when they conference on the case. Aaron, how about you? Was there anything in particular that you were hoping would come out?
Yeah, I would have liked to seen a better understanding on and conveying to the justices the fact that most of the censorship is not Rob Flaherty at the White House calling up a senior executive at Facebook, pitching a fit, screaming at him, dropping F-bombs, and threatening the power of the president against him. That accounts for maybe 1% of 1% of the censorship that we've seen at the behest of the government. What's actually happened in most cases is that the government has suborned what some people call gongos, government-organized NGOs, places like the Stanford Internet Observatory, the Atlantic Council, places that are government-funded, that are organized at the behest of government officials, that are often staffed by former government officials in places like CISA, the Department of Homeland Security. And these third parties then do much of the 24/7 grunt work on the censorship. And it involves very sophisticated AI, basically scraping the internet to see what stories go viral and what stories threaten to go viral. And they're more or less like an engineer mixing a record, where if Jay's tweet or Jenin's post on Facebook or something that I say online is starting to gain traction, and it's contrary to one of the government's preferred narratives, they can literally turn the volume down on that in all kinds of subtle ways that prevent it from going viral, without even the person being censored realizing that it's happening to them. And they can, in fact, do things in the opposite direction to artificially amplify things that organically wouldn't go viral. We have these accounts over here that we think are favorable to our ideas, and they're not getting a lot of traction. We need less snare drum, but we need more cowbell. We're just going to turn the volume down on this. We're going to turn the volume down up on that. That's the level at which most of the censorship is operating, and that's how you get hundreds of thousands of Americans censored literally tens of millions of times. It's not just one person identifying half a dozen accounts that we don't like. I mean, that's egregious, that's wrong, that's clearly unconstitutional. That's probably the easiest example for the justices to wrap their heads around.
Well, and I think it's a good example too, because it's, when, and I think Justice Kavanaugh and Justice Kagan were both saying that they didn't sort of give the full context, but essentially they were saying, when they were in the White House counsel's office, they would call the newspaper all the time and tell them that they were mistaken about a story. And they seemed to be struggling to understand what the difference was between that and what was happening to the social media companies. And one of the answers to that is what Dr. Kheriaty just said, which is these are sophisticated scraping all across the internet, taking down multiple posts of hundreds of people on a topic, not just taking down one article in one paper. It's a very different kind of thing that's going on there. One of the funniest moments of the oral argument, I thought, was right after Justice Kagan and Justice Kavanaugh talked about their experience. Chief Justice Robert piped up and said, well, when I was in the government, I didn't censor anybody, which was funny, but it was also telling to me that he used the word censor. And I'm glad that he recognized that what Justice Kavanaugh and Justice Kagan were talking about was a form of a censorship. Just because they were doing it when they were in the White House counsel's office doesn't mean that it's okay. I do think there's a question about, if it's a one-off thing, that's different than systematic, right? One of the other differences between what was happening with the social media companies is you had systematic badgering over and over again, follow-ups when they didn't take things down, right? And that's, again, very different from even what I think Justices Kavanaugh and Kagan were talking about was their experience, presumably contacting print media in the late 1990s in Justice Kagan's case or the early 2000s in Justice Kavanaugh's case. Jenin, I wanted to come back to you on again on some of these things that maybe got lost in the argument. There seemed to be a lot of discussion about national security and safety hypotheticals, and I'm not sure that. And we talked a little bit about Jay did here with the TikTok example, but some of the national security examples I thought went a little bit off track. Did you have a thought on that?
Well. The national security examples, I just think they're very inapposite, especially when you're looking at the entire record we have here, which involves the government, censoring people for saying that natural immunity is better than the vaccine or that masks don't work or something like that. It just has nothing at all to do with this case. And there are, frameworks under which the government can be involved in censorship of national security issues in certain circumstances where, there might be an imminent threat to the lives of Americans. But
right. Don't run that story until we pull our operatives out of that, out of that compromised situation or something like that.
Yeah, that's entirely different from a situation where you have government actors forcing or pressuring or working with tech companies to get rid of entire lines of thought, entire narratives. I mean, if you tried to tweet anything negative about the COVID vaccine in 2021, I know personally it got censored, or you just didn't do it because you didn't want to lose your account. That was the other way of dealing with it. But that's just a totally different situation than something very specific that might, present an imminent threat of harm to Americans. And certainly there are exceptions under the First Amendment for government involvement in that.
Well, one of the things I think that did come out to a certain extent in the oral argument, maybe not as much as I would have liked to have seen it come out, is the fact that you're talking about third-person speech when you're talking about suppressing people on the internet, right? When Justice Kavanaugh or Justice Kagan was calling, let's assume the Washington Post, New York Times, and asking them to take down a story or fact check a story that they were running, they were talking about a story that newspaper had run, right? So that's first person speech. They're asking them to think about whether their own speech was as accurate as maybe it could have been. When these, when CISA and these other federal agencies today are contacting the social media companies to shut down Dr. Bhattacharya's tweet or Dr. Kheriaty's tweet, they don't ever find out about it, right? Yeah. They're not part of the conversation. This isn't a persuasion. This is shutting down third-party speech that you never find out about. That's a big difference, right, from my perspective as well.
And another thing that I thought didn't come up enough was that the government keeps drawing these analogies to other cases in which the government pressures private industry to do the right thing. Greenhouse gas emissions are too high. Please help us bring them down, whatever. And yes, the government can do that. It can try to persuade private industry to bring down greenhouse gas emissions, but there's no constitutional right to have a certain level of greenhouse gas emissions, whereas there is a constitutional right to free speech. So the government can't use its powers of persuasion or the bully pulpit in order to infringe that's Americans' First Amendment rights. That's where the government's rights end, is where our rights begin. And I don't know that enough of the justices understood that.
Yeah, there's this idea that because it's the bully pulpit, that gives the government some additional power that it wouldn't have. But I think, and I do think this came out. I think the Solicitor General of Louisiana did a decent job of making this point, including in his opening statement, that it's not the bully pulpit when the president or another senior official goes behind the scenes, right? The bully pulpit is public in front of the world saying, you should do more of this, you should do less of this in a sort of non-threatening way. That's very different than going behind the scenes privately, surreptitiously demanding in a threatening way to take things down. I think the line in the opener was, that's not the bully pulpit, that's just bullying. And there's a big difference between those two things. And I think that came out to a certain extent. Yeah. But again, I think that we could have come back to that more than we did. One of the questions that came up, Aaron, was whether this censorship is still going on. There's this sort of idea that, now that Elon Musk owns Twitter, that everything's hunky-dory. Is that your experience?
And that COVID is over. So.
Right.
So there is still plenty of censorship going on. I think the government admitted as much yesterday when one of the justices put the question to them toward the end, are you arguing that this case is moot? In other words, are you saying there's not going to be any future harms to the plaintiffs or potential harms to the plaintiffs because all of this activity has stopped? And they said, no, we're not arguing that, which was an indication that, if you don't join us here, that basically gives us a green light to continue doing this. And so
they censored people yesterday, they're censoring people today, they're going to censor people tomorrow.
That's right. They have no intention of stopping. I think they're trying to do it a little more surreptitiously now, knowing that we could get communications on discovery in this ongoing case. So they're trying to figure out ways to do it perhaps with more subtlety.
Don't put it in emails, maybe.
Yeah.
Go back to the Kagan-Kavanaugh phone call.
Exactly. But I actually had a conversation a few weeks ago with Elon Musk about this, and my impression on Twitter is basically things got a lot better when he took over, and initially he was in the position of CEO, and he did a lot of house cleaning, and we went from what a lot of people refer to as Twitter 1.0 to Twitter 2.0, and Twitter 2.0 still had some censorship, but it was way better. Since he stepped down and assigned another CEO, I mean, the guy's got a lot of companies to run, so I don't blame him for this. We've regressed to what feels like Twitter 1.7. Okay, so it's better than it was before he bought the company, but it's not where it needs to be. And I would certainly Facebook, the needle hasn't moved at all on a platform like Facebook. YouTube is probably the worst. YouTube, which is owned by Google, is probably the worst in terms of censorship. I'll mention.
I was going to say YouTube is the one that took down the last lunch and law we did on this case. So I hope you're watching the live stream because this may not be up tomorrow.
So it's absolutely still happening, and I think the evidentiary record suggests that much of it, perhaps even most of it, is happening on certain topics at the specific request and because of the specific pressure exerted by the government. So it's not private companies acting in a sort of independent way.
There was a Washington Post article just a couple months ago about how the Biden administration was telling the companies to censor misinformation about inflation. And there was literally something about like a burger being $17, and obviously that doesn't look good for Biden's economy. Right. So we know they're still doing it. I mean, and there was also a Politico article where they were saying that this case was responsible for a rise in vaccine misinformation because they weren't able to combat it during when the Fifth Circuit's order was briefly in effect.
Well, what was striking was there was an assertion made by the government that it was an exceptional circumstance, and during the emergency, there's effectively like a vaccine exemption to the First Amendment. I mean, I looked at the First Amendment. You guys are lawyers. Can you help me? Is there a word? I mean, the thing that struck me about that is that there's no limiting principle. Like, what makes vaccines special? What makes is there any restriction at all then if the Supreme Court grants this exemption to the First Amendment just in this case? Well, why just in this case? What makes it different than any other case?
Right. They kept saying it's like a once-in-a-lifetime pandemic, so maybe there's some, we have to have some more relaxed rules. I mean, you can. What makes this so much more dangerous than anything else?
Well, it's a once-in-a-lifetime Biden inflation, too, right?
Exactly.
So, hopefully we won't see that again.
Well, on the extreme end of that spectrum, we had Justice Jackson proposing a totally novel doctrine of the First Amendment when she basically said, going beyond what the government was even trying to argue, the government was at least trying to say, no, we're not coercing. We might be encouraging, but we're not coercing.
And if we were, it would be horrible. And
yeah,
terrible.
Right, exactly.
I mean, the Principal Deputy Solicitor General Brian Fletcher, who did a fine job on behalf of the government, but his whole line about how, this would be horrible if this were happening, it's like, yeah, and it is happening. So I'm glad you at least agree that it's horrible. But
well, she seemed to propose that so long as the government believed it had a compelling state interest, then it could go beyond encouragement into the realm of coercion, and there wouldn't necessarily be a First Amendment issue there. And I found that claim to be just absolutely shocking.
Yeah, I did too, and that was another quote that I had circled in my notes here was there was an exchange between Justice Jackson and the Solicitor General of Louisiana, where the Solicitor General said, I guess the top line question I would ask is, has the government set out to abridge the freedom of speech? And in this case, you see that time and time again because, and then Justice Jackson cuts him off. But that's not the test for First Amendment violations. And then he replies, well, Your Honor, this flows from the plain text of the First Amendment, right? Justice Jackson, no, I understand, but we have a test for a determination of whether or not the First Amendment is actually violated. So the text of the First Amendment isn't the test? I mean, and frankly, I mean, she's not alone in this. I mean, she sort of said the quiet part out loud, but all of the justices were proceeding yesterday as though coercion is the test, maybe substantial encouragement is the test. No one was out there saying that abridgment is the test, at least not from the bench. But the text of the First Amendment says abridge. And abridge isn't a word we use a lot these days, or abridging, but it just means diminishing or reducing the amount of speech. Well, do you think that if the White House systematically contacts the social media companies and asks them to take down information, that's going to diminish speech? Of course. And if that's the standard, it's very easy to reach that decision. It only becomes a difficult question when you start throwing in the tests, the sort of weak doctrines that the court, and not necessarily this court, but that over time the Supreme Court has come up with, suggesting that you have to show coercion or something else rather than just abridgment.
And of course, anytime a government official engages in this behavior, they're going to believe there's a compelling state interest. Otherwise, why would I be doing it? There's obviously a compelling state interest in combating misinformation about inflation or about or whatever. So, I mean, that just gives a blank check to anyone, and then places the burden of proof, the impossible burden of proof, on those who are censored to come back and try to get some redress for those harms.
To kind of follow up on the burden of proof thing, because there was another major point made about traceability, like the idea being that in order to show that there's a First Amendment violation, the named plaintiffs have to say, okay, here's the pattern of exact emails leading to my free speech rights being violated.
Right. Where's the trail of breadcrumbs? Right.
Yeah, exactly. But the problem with that is, like, if you have a mechanism of suppressing whole themes, whole ideas, right? So, someone says the Great Barrington Declaration online on a platform where I'm not on, and it gets suppressed simply because they put the words Great Barrington Declaration in their post.
Pretty easy words to use that aren't going to pull in. Barrington's not going to pull in a lot of other topics, right?
And that's exactly how the AI censorship is working, by the way.
And so that means that there's not going to be a trail of breadcrumbs, and that means that if you apply that test, essentially what you're saying is that the First Amendment is not enforceable. Right, there's no legal redress for the mass violation of free speech rights.
Yeah.
And so that, it was very frustrating to hear that principle, that standard of traceability. Where's the line of emails leading to this tweet being suppressed, or that person being pulled off YouTube? I think that if the court applies that standard, the First Amendment is a dead letter.
Let me ask both of you: how does this harm scientific inquiry to have this sort of censorship taking place, not just COVID, but other places too?
Science and censorship are absolutely incompatible. Science is not a set of completed doctrines that are unassailable. Science advances by hypothesis, conjecture, testing, refutation, Open debate and discussion are the stock and trade of scientific work. Put a group of a dozen scientists who work on a particular problem together in a room for an hour, and what will they do? They will argue endlessly. No, it'll be friendly, but it will be fierce, and they will debate. And that's actually how scientific progress and medical progress are made. That's what we do routinely in a teaching hospital or in a grand round session in a medical institution. And so the idea that you can fixate some sort of scientific consensus and say anyone who challenges this is going to be shut out of the conversation. They're going to be censored, they're going to be silenced, they're going to be sidelined. You've basically brought the scientific enterprise to a grinding halt. Furthermore, as Jay you could probably talk more about the illusion of consensus that was created through censorship during COVID, which also produces very serious problems for the dissemination of scientific information.
Do you want to add to that?
Well, maybe I'll just do a very, very specific example. Like, did the United States fund the labs in China that created the virus and caused this deadly pandemic? Right? If you said that there was even a possibility in 2020, you were a conspiracy theorist, you were a racist. There was something wrong with you, and yet they were
because you were challenging St. Anthony. Right?
I'm trying to think of like a more important scientific question than did scientists cause a deadly pandemic? I mean, there isn't one, right? And there were
but with gain of function research that was being done in the lab, and the question was the U.S. government in fact funding state-sponsored research in China into gain of function research on bat viruses?
In China and the United States. So this is if it's true, this was a Chinese American Chernobyl, what just happened, right? It's not there aren't very many man-made disasters in the history of the world worse than that, and yet scientists I know silenced themselves in 2020 because they did not want to be seen as conspiracy theorists. They had a scientific case to be made, and it was actually Twitter 1.0. This network of people, many of whom got smashed down during the Twitter 1.0. This is called Drastic, that sort of brought out some of the scientific evidence that led to a real change in the scientific community, and now it's a live, active discussion. Many scientists think that this was the Chinese American Chernobyl.
And we have pretty airtight proof that at least Facebook censored it because of the government. Because there's an email from Nick Clegg, the former deputy UK Prime Minister, who now is an executive at Meta, asking another executive, can you remind me why we censored the lab leak theory? And the other guy says, because we were under pressure from the White House, we shouldn't have done it. I mean,
well, at least Nick Clegg recognizes they shouldn't have done it, but they did.
It was the other guy who said we shouldn't have done it.
It was?
Yeah, Nick Clegg was asking why they. Yeah, doesn't really matter, but yeah.
Yeah.
So maybe I could. I have here embroidered a list of very highly credentialed, credible doctors and scientists. These are just among my friends and close contacts that were censored during the pandemic. These are people like Jay and Martin from Harvard, Marty McCary from Hopkins, who we had dinner with last night. So the people who were being censored were not crazy people saying aliens have implanted a chip in our brains and are controlling us from outer space.
I mean, some of them were.
Well, fine. Fair enough.
But they have the right to say
that. They have the right to say that. I mean, maybe they're right. How would who's to say, right? A little intellectual humility, a little epistemic humility would be a good thing.
There's no aliens.
Jay's going to straighten me out. But yeah, I mean, the point is this dragnet captured everyone across the spectrum, including people who needed to be part of the public conversation on questions like COVID origins, on questions like safety and efficacy of novel mRNA products. And they were systematically shut out. And these are the seeds of very bad things down the line. The 20th century political theorist Eric Voegelin studied the totalitarianisms of the last century, from Nazism to Italian fascism to communism. He said the common feature of all these totalitarian regimes was not concentration camps, barbed wire fences. It wasn't secret police, men in jackboots. It wasn't mass surveillance, which, by the way, we have these days. He said the common feature and the starting point of all these regimes was the prohibition of questions. So the regime monopolizes what counts as knowledge, what counts as rationality. And if you raise your hand and pose any questions, if you bring forward any opinions that the regime doesn't like, they don't sit down and argue and debate with you. They simply shut you out of polite conversation. And if you still won't shut up, then they'll send you to the gulag or to the digital gulag in this case. But
it's not always so overt, right? Because
exactly.
I was educated by a friend here in the room, who many of you know, who has some direct experience with authoritarianism, and said, look, in Soviet societies or in Russian societies, they don't necessarily come down on you like a pound of like a ton of bricks. They might come up and be very nice about it. They might say, Sergey, we want you to study at the university. You want to study at the university, but if you keep saying these things, it might be more difficult for you to study at the university, right? And Sergey understands the threat, right? It doesn't have to be. That's right. It doesn't have to be highly coercive in order to get the point
across. That's exactly right. And Hannah Arendt points out that at the end point of this process, you don't even need the gulags and concentration. You don't need because everyone is surveilling everyone else all the time. And gradually, slowly over time, people absorb that atmosphere and they begin to self-censor, like the scientists that you described. They don't need external threats. They just see an example of what happened to me at the University of California, what happened to you at Stanford, and they say, I don't want to stick my neck out like that.
And I wanted to use your jacket as a good segue too, because I saw Tracy Hoag's name on there.
Yeah.
It was one of our other clients in the case that Jenin had out in California. Trying to successfully shutting down a law out there that was trying to take away doctors' licenses if they said anything about COVID. And I don't know if there were any particular examples from that litigation that jump out to you, Jenin, in terms of sort of scientific ideas that were batted around. The one that jumps out for me is, and I can't remember, whether it was Dr. Duracetti or one of the other.
Is this the intubation?
Yes.
Yeah, that's Duracetti.
Yeah. So early on in the pandemic, the standard when people were admitted to the hospital with COVID was put them on a respirator, intubate them. That was sort of how they were treating folks. And he was very skeptical of that particular regimen and thought, I think I can get better results if I don't do that for my clients. When they come in, my patients when they come in. And over time, it turned out that he was getting better outcomes. And now it turns out it took maybe a year or two for the whole medical community to turn around and recognize actually what we were doing in the beginning, that was not the best way to handle that situation. We were in some cases maybe making matters worse by doing that. You don't get to that result if you don't have the free exchange of ideas. If you're threatening doctors' licenses because they're doing something with their patients that isn't keeping with the contemporary scientific consensus.
Exactly, yeah. And I'm Dr. Bhattacharya, after he was persecuted for saying lockdowns were a bad idea, and especially school closures. Finally, 4 years later, the New York Times published an article yesterday saying, oh yeah, that didn't stop the spread of COVID at all, and it's been disastrous. But did you get an apology? I don't know.
Still waiting?
I don't care. What I really want is the policy to, we should be burned into our memory. Keeping schools are really important for kids. I thought that was already burned in our living knowledge systems, but that should never happen again.
Well, I don't think it will happen again because I think most people kind of get it. But the problem I see is that with the next emergency or whatever crisis, censorship will still be.
Yeah, absolutely.
That's the key point, right? You correct bad policy by letting people say it's bad policy, right? And if the outside critics are right, they'll eventually win if the system's working right. You shut that down, you're gonna end up with bad policy. You're gonna end up with bad science. You're gonna end up.
And there's no self-correcting mechanism.
Yeah.
One of the things that I think came up from several justices yesterday was this idea that, well, do we need to protect people from false speech? And Jenin, I thought the First Amendment protected false speech, but now we have this The government seems to think if it's misinformation, disinformation, or malinformation, that's a justification for censorship.
Yeah. I mentioned, or I touched on it a little bit earlier, but I mean, that's the whole idea behind the First Amendment is nobody has a monopoly on the truth. The government doesn't know what's true, so we can't put them in charge of being the ministry of truth. We all, as Americans, American adults, get to decide for ourselves what's true and what's false, and we're capable of making those assessments. And, you know, if someone's posting something and telling kids to jump out of whatever windows, government officials can say, this is a really bad idea. Please don't do this. Their parents can talk to them. And by the way, when it comes to kids, I mean, there are other ways of dealing with their access to the internet that, you know, might be reasonable.
Sure.
So I think those examples are also bad because kids are kind of a different category of people. But the idea that censorship or just silencing speech is the way of dealing with problematic ideas is just wrong. I mean, it just makes them go underground. It's much better to have an open dialogue where the ideas are actually taken down publicly. Yeah. I mean, taken down intellectually, not
right.
Forcibly.
Yeah.
Right. Well, and there was a case, I think maybe 2012 case, US v. Alvarez, this is the so-called stolen honor case, where someone was lying about having military ribbons that and medals that they didn't have. And I seem to remember that was a 5-4 decision, but the court did uphold that was protected free speech, even though it was false speech. And I just want to reiterate, the speech we were talking about here was true speech on the part of Dr. Kheriaty, Dr. Bhattacharya, talking about things like a natural immunity to COVID. But false speech is protected too. And go back to one of my favorite Supreme Court justices, Robert Jackson, from 1945 in the Thomas v. Collins case, said something very similar to what Jenin just said, which is that we're all the watchguard for our own truth because the founders didn't trust the government enough to put it in charge of being the watchguard for truth. And it's not the government's job to police that line. There's a place for the government to police the line between legal speech and illegal speech. No one, at least at NCLA, is going to object if the government is calling these platforms and telling them to take down illegal speech. If there's child pornography on the platform, take it down. But what we have in this record, Jenin, is the FBI admitted that it does not call the platforms when it discovers child pornography and ask them to take it down. But it does ask the platforms to take down misinformation and disinformation about things like COVID and inflation.
That's right. And this case illustrates perfectly that once government officials have the power to censor, that they'll abuse it. I mean, here you had government officials in the White House telling the platforms to take down borderline content. That's what they call true content that might lead people astray or might lead people not to get the vaccines, including personal accounts of adverse effects from the vaccine. I can't think of a better illustration of why the government shouldn't be in the business of censoring.
Can I give an example? It was really funny in the evidentiary record that in 2021, April 2021, the J&J vaccines, the CDC found a negative safety signal. And so the CDC put out a warning, said, and paused the rollout of the J&J vaccine. The White House shared the CDC's announcement on its Facebook page that they're going to pause the J&J vaccine. The very algorithms the White House induced on identifying anti-vax groups identify the White House as an anti-vax group. And then so the White House got censored. And then you got the Rob Flaherty writing to the Facebook saying,
that was the "Are you effing serious?"
Yeah, you serious? They're like, why are you censoring us? It's like, so the White House got caught in its own censorship trap.
Yeah.
Feels good, doesn't it? When it happens to you. Now you know what it feels like.
Voiced by your own petard, as they say, right?
It's infuriating, and the White House never censored false speech that supported their narrative. So of course they're going to use it. In fact,
can you say that again? That's such an important point.
The government never censored obviously false speech that most people would consider clearly false, as long as that speech supported their preferred policies. So there was no outlandish claim about the miraculous cure from the vaccines that was ever going to be censored, even if it was wildly exaggerated, because it supported what the White House was trying to do or what the CDC was trying to do at the time. And in fact, I would say that true speech that's compelling is precisely what's most fiercely targeted, because that's precisely what's most threatening to the regime's interests. Someone of credibility saying something that, presenting evidence for something that contradicts what the government is saying is the biggest threat to their interests. And it's precisely those people. And those
you might say
people,
it's double plus on good.
Exactly. And, you know, Orwell understood this very clearly. And that's why in his dystopian novel, they had to establish a regime in which, you know, people were content with manifest contradictions. I mean, the whole plot of that novel hinges on the main character, Winston Smith, admitting that 2 + 2 is 5. And then once he does that, once someone can do that, you have total control over them. So the truth is fiercely fought by any regime that props itself up on lies or doesn't have the humility to admit its mistakes. We're allowed to make mistakes, but then we have to reassess. We have to have an open public mechanism in place that would allow us to say, okay, maybe ventilation of COVID patients prematurely was not the right way to go. People died unnecessarily because we did that. We're going to change course now, right? That's how things should work. But you know, we have people in power that are not very inclined to admit that they've ever made a mistake, and they'll double down, triple down on their prior mistakes just to save face. That becomes a strong motivating force, I think, that pushes a lot of the censorship.
We're going to open it up to audience questions here in a minute, but I want to give each of you a chance to for any additional takeaways from the oral argument, particularly if there are any. If you want to talk about the consequences of what an adverse decision would be, or a very adverse decision, or what the consequences of a positive decision would be. Jay, can we start with you?
Yeah, I think the stakes are incredibly high. I think if we lose this case, I mean, there's not a shred of the First Amendment left in this country. Like, the government essentially can declare whatever emergency it wants. It can declare that what it wants, the suppression that it's doing is in service of some state interest, and there's no limiting principle. I don't see the American Republic looking at all like what it looked like before if we lose this case.
Aaron?
Yeah, on the question of the burden of proof on traceability, if the government basically says, you know, one or another of the plaintiffs doesn't have standing because they couldn't identify the email where they were named by a government official, that sets up a roadmap for more massive censorship than would have to happen if the government named names. I mean, you know, people going through accounts and saying, take down this guy, take down that guy, that's a lot of manpower, that's a lot of work. But if the government can simply go to the social media companies and say, if you allow any postings favorable to the Great Barrington Declaration or favorable to this idea or that idea, then, you know, there's going to be trouble for you. Basically, you've just taken an entire topic of public conversation off the table, and you've censored more people than, you know, anyone could possibly count. And so a legal doctrine like that is going to set up an even more massive censorship regime. The government's going to have a free hand to do anything so long as they don't name names. Well, that's not that hard to do when really what they're targeting is ideas. Really what they're targeting is evidence for certain things.
Jenin, how about you?
Well, I share Jay and Aaron's concerns. I think an adverse decision would be disastrous. Of course, there are various iterations of what the decision. It's probably not going to be like win or lose. They're going to say very specific things that are going to have implications depending on what those things are.
Right. So there's really three questions, right?
Yeah.
One is, do any of the plaintiffs have standing? Because at least one plaintiff has to have standing in order to reach the merits question. And I don't know about you, Jenin, but my general feeling was that there seemed to be a majority of the justices who were going to find standing for at least one plaintiff, maybe Jill Hines.
Jill Hines,
Her name came up a lot yesterday.
But if it's only Jill, then it runs afoul of what Aaron just said. Like okay, Jill has I was put on a blacklist on Twitter, but we don't have an email saying that the government asked for me to be put on the blacklist. But the government opposed GBD, right? So and they were pressuring the platforms to take down GBD-like content.
How much more evidence do you need?
So if it's just Jill, that doesn't help.
Well, but to get to standing, that's all you need. And then the next question would be on the merits of the First Amendment. because they won't necessarily, once they find standing for one plaintiff, they won't ask the question
they
for the
won't
rest
ask
of
the
them
principal.
necessarily.
Yeah.
They won't go through because they only need it for one, and once they all agree on one, then that's where they are. So, but then you'd have the question of the First Amendment and what's
Yeah.
the standard, and was the First Amendment violated here by this conduct?
Yeah.
And then if they assume that at least some of the conduct violated the First Amendment, then the last question that they'll ask is about the preliminary injunction and what the scope of the preliminary injunction should be. Should the full scope be upheld? And even Justice Gorsuch asked the Solicitor General of Louisiana, would he limit it at least to the 5 platforms that discovery, or would he limit it in any way? And he said, well, I would limit it to the 5 platforms that discovery was obtained from. And I was, I'm okay with that concession. I think it's hard to get an injunction against someone that you don't have discovery from. But then he said he would also be willing to limit it to the 7 plaintiffs that were in front of the court. And I just disagree with it. I don't think that he needed to make that. I don't think Justice Gorsuch was asking for that concession. I don't think he needed to make that concession. And I think that concession's wrong for an important reason, which goes back to a little bit what Jay was saying. Each of the people who are involved in these online debates, they're not solo actors. They're not in a silo by themselves. They're following other people are following them. They're having an exchange of views, and you need to be able to stand up for the other people who are being censored as well, and not just, the fact that you're on a blacklist, that's a problem, but if the people that you want to follow are on a blacklist too, why that harms you as well. That harms your ability to engage in free speech, because part of free speech is also being an active listener and hearing what other people are saying and being able to participate in the debate. So maybe we'll throw it open to questions. I think we'll go with John Vecchione, other co-counsel in the Murthy case here.
So just first, is it on? Yep. Okay. So first, one correction. Alvarez was 8-1.
Oh, good.
With only Alito as the 1.
And he seemed to be in a good place yesterday.
Exactly. So that was it. But it struck me that we didn't get any questions on standing from any of the 6, I'll call them. So I didn't really hear anything on that. I mainly heard on merits, and I heard the injunction was a problem. And I've said before, if I was the advocate, I would have conceded that to Gorsuch because you need his vote. It's not a platonic exercise we're in. But my question is this. If we do win on standing, and then they go to merits and they say, hey, the one call is never going to be the problem. Here's a structure of what we think is the problem, and we think the injunction is too large, go back and do it again. What would you guys think of that in this preliminary stage?
Do you want to go first?
You go first.
Well, what I would say is, look, it's very simple to write an injunction in this case. Thou shalt not ask for lawful speech to be taken down, period, end of sentence, end of injunction. That's all you need. If it's lawful speech, the government shouldn't be asking for it to be taken down. They shouldn't be asking nicely. They shouldn't be asking meanly. They shouldn't be asking at all. They shouldn't ask in a boat. They shouldn't ask with a goat. They shouldn't ask to take down lawful speech, period, right? It's not hard. It's not hard. So that's where I would like to see the court go.
I agree with Mark.
I will take any win at this point. I mean, I'm not a lawyer. I just play one on TV sometimes. But my understanding is it's hard to get an injunction because we've only had limited discovery, and we're asking the court to intervene before we've had the adversarial trial process and get a final ruling.
But we do have a 20,000-page record, which
yes,
usually don't have at the
I don't want to
preliminary
minimize.
injunction
We have
stage.
enormous
Yeah.
evidence. We have overwhelming. What is shocking about this case is just how overwhelming the evidence is and how egregious the violations were, and that all 9 of them couldn't readily and easily grasp that. I'm still trying to process and comprehend that. But I will take whatever I can get from the Supreme Court. I think an injunction, even if it's more narrowly tailored, is a strong warning shot across the bow to government officials, and it will have a chilling effect. And they will continue to try to censor, but it will make their job more complicated. And I want to put a dent in this censorship leviathan now, not in 2 years or however long it's going to take to get to a final ruling.
Absolutely.
And it's going to take a lot more work to dismantle the entire thing than just one case. But if this can be a first big step in that direction, then I'll be happy.
More questions?
I've been watching the Supreme Court for many, many years, and I have never seen an argument where the entire court seemed to be capable of evading the central factual and legal issues in front of them. Everything you have all said today needs to get out and aired in the public now. I think that we need editorials, we need articles that point out the mistakes in doctrine, the misunderstanding of how this censorship actually takes place, and in a way that would embarrass the court if it ruled against you. Because it is very clear to me from that argument that it does not seem they quite understand the record before them. And I cannot exhort and encourage you enough to get out there and write and expose all of these deficiencies in their understanding, in their doctrine, and in the factual background that seems lacking in yesterday's performance. So I hope you do that.
Well, and I'll underscore that, Peggy. I think I was sitting next to Peggy yesterday at the argument, and if you want to save the First Amendment as we have come to know it, don't wait for the decision to come out. Engage now and get these points across now. Write the op-eds, talk to your friends, get the message out now. Dr. Dolan?
Perhaps to follow up a little bit on what Peggy said, I think one of the unfortunate problems that we are facing here, and I think what the court is trying to obfuscate, is the situation where the political zeitgeist today and IP side, right? The kind of the views of those organizations, the Facebook, the Twitter, they seem to be aligned, and so the court can say, "Oh, it's not Joe Biden and his administration taking down these things. This is just Twitter and and Facebook and whatever doing it on their own." And back in 2008, I kept warning my friends, like, don't be so hot on Obama exercising executive authority because you never know who's going to come next. And they're like, well, never going to happen. Of course, administrations change. And so in those op-eds, it may be worthwhile pointing out that you might be happy with whatever's being taken down now, but those, views may not always be aligned. And, it might come back to bite you much like it did to the White House.
I've been surprised to the degree to which that, someday the shoe might be on the other foot, that argument, you'll be on the receiving end of this. It doesn't really seem to gain traction with people who are not already on board with this issue. I don't know why. Perhaps they just believe that their ideology, their reigning sort of zeitgeist will remain in power indefinitely, which never happens historically. The other thing I'll say about this is Justice Barrett, who was a little bit hard to read, asked a very interesting hypothetical at one point, which suggested to me that she understood that even a relationship that looks entirely cooperative may be problematic constitutionally. And her hypothetical was, could one of these companies decide we're going to give over all of our content moderation to the government on this particular topic? Willingly.
Yeah.
Without even being asked, would that create a problem constitutionally in terms of the government's action there? And the Counsel for the Government, Solicitor General, admitted, that would be problematic. So I think that was a way of suggesting a sort of joint action entanglement issue might be there, even when the coercion looks more subtle or less overt. With that said, we've also presented plenty of examples in the record where the social media companies did try to push back. And some of those examples surprised us. I think the assumption initially was maybe it'll be hard to prove coercion because it'll look just hand in glove and they'll be kind of on the same page and really cooperative. But the social media companies clearly wanted the government off their back. They clearly tried to push back. And it required a lot of back and forth for them to be finally beaten down to the point where they caved in.
Some of them also, some of the employees also clearly had a pretty admirable understanding of free speech. I mean, there was a quote from Nick Clegg about how a request from the White House would constitute a significant incursion into the boundaries of free speech. There were other exchanges where they said, we really don't want to do this. We think people should be able to talk about their experiences with the adverse effects of the vaccines. And the administration's responses were more or less like, well, too bad. You're causing vaccine hesitancy, so get rid of it.
Yeah, and that was Andy Slavitt, I think, on one of those responses from the White House.
Yeah.
Additional questions?
I'm trying to run this through my head right now, but there seems to be a bit of a double standard from the administration. On the one hand, there's the attitude they're taking that they can go to Instagram, Facebook, or YouTube, or Google and ask that certain unfavorable or critical views be taken down that they don't like. And that this is not a threat to free speech or national security, et cetera, because they're doing it. And yet at the same time, they're saying that, President Biden is saying he will sign a bill to prohibit TikTok in the US or force its sale for the very reasons that the Chinese government may do the thing that he wants the US government to do. Now, of course, the Chinese government's a foreign government, not always the friendliest government, but the first principle of free speech and keeping the government's role out of the US government or the foreign government's role out of our free communications is still there. I was wondering if that had any role in the discussions.
It didn't come up yesterday.
No,
but
the TikTok ban didn't come up, and I think that bill is actually a stalking horse. I'm not a fan of TikTok. I think it's like crack cocaine for the adolescent brain. So I'm favorable in general to the idea of reducing young people's access to that platform, and I think it is a data gathering mechanism for the Chinese Communist Party. Those are problems. I think those can be handled on the back end of the software, the way that it functions here in the United States. Built into that legislation, it basically is giving broad powers to the president to essentially sort of define which social media companies he's going to take authority over on the basis of very poorly defined sort of foreign ownership. You know, there's some foreign people have a partial stake in the company, or it may be influenced in some way by other. So it's deliberately written in such a way as to give the president overbroad powers over social media. And so, on the one hand, it looks hypocritical, but on the other hand, if you scratch beneath the surface, I think it's another step in the direction of.
Completely agree, but flipping around from what the Chinese were going to, that the U.S. government could do the same thing, and this is a tool of influence to influence social media companies, because the public forum has increasingly moved into private hands, and if you can control those few actors that control those few public fora in private hands.
Right.
It's a possibility. I'd like to try to get a couple more questions in. Just
a real fast point on this, and it's related. It's not exactly on point, but the excuse often given for suppressing misinformation is that it comes from a foreign source. I don't understand that. I don't understand why, if it comes from a foreign source and it's misinformation, it has any separate protection or lack of protection regarding for free speech. If it's legal speech from a foreign source, why should the United States government prohibit it?
Well, it might have less First Amendment protection as a matter of doctrine, but what we've often seen is that an American will see a piece of that speech and they agree with it, and then they'll forward it to their friends, and then it gets shut down. Well, at that point, it's been adopted, it's domestic, and the person who's retweeting that has a First Amendment right to do that, and it's still being shut down. So I do think there's a problem there. I think I saw another hand. Yes. Dan.
Deep nerdery. How do you think about this case along with the Texas and Florida cases, as well as the NRA case that was argued right afterwards? And I thought it was really interesting that they paired this case and the NRA case.
So I didn't listen to the NRA case. John Vecchione did. Do you have a response to that, John?
So all three cases were referred to by the justices in relationship to each other. Ben brought up that all of the social media outlets had told the justices in Net Choice that the key thing that they needed was editorial control of their platforms. And in our case, they gave it up to the government. And then in Vulo, the issue there is, as I understood, I didn't stay for all of Neil's argument, but it looks like that the smoking guns are so large that the New York government did this to the NRA because they hate the NRA and not for legal violations. And in fact, Justice Alito said, "What? They're just rubes because they did it so blatantly. But if you do it not blatantly, then you can get away with it." So I think that all three cases, I wouldn't be surprised if they either came out on the same day or they came out within one day of each other, because all of them in their heads are discussing these cases together and how they interrelate and what's happening. So I do think they're going to relate them, as well as the case that came out Friday about whether you can block. That was on Barrett's mind, because she asked specifically, what if someone calls you up but they're not responsible for whatever that area is? And so she wants some kind of link of that sort.
Do we have time for maybe one question from online?
Well, we have a good one from Don Elliott, who wants to know, does the government have free speech rights? Does the government have a right to say its piece? And if so, does that tell us anything about how an injunction ought to work and how it ought to be shaped?
Do you want to speak to that, Jenin? Whether the government has free speech rights?
Sure. The First Amendment protects people against government. It's not for the government, and government can't use its own supposed right to speak in order to infringe on our First Amendment rights. That's just a ridiculous.
Yeah. But no one, certainly this injunction is not, and no one else is proposing that we abridge the freedom of speech of any government official to speak publicly. What we oppose is them going backdoor behind the scenes and preventing other Americans from speaking. So the argument from the other side seems to be, oh, you're going to hamstring us and we're not going to be able to speak. No, you're just not going to be able to force the speech of others to be taken down. That's really the crux of the issue. So that's a red herring.
Right.
Well, and it's not clear to me that if the government is asking to take down lawful speech, that's really speech that the government's engaged in. That seems like more action conduct that they're involved in there. Well, that's all we have time for today. So on behalf of the New Civil Liberties Alliance and our esteemed panel, I want to thank you all for attending this Luncheon Law event entitled, Will SCOTUS Topple the Government's Censorship Industrial Complex? Would you all join me in thanking our panel?